Morning. Welcome to the Committee on Rehabilitation and Social Services. It's nice to see folks up and awake, 8 o'clock on a Friday. I'd call the committee to order. Will the clerk please open the roll?
You have a quorum, Madam Chair.
Thank you. Okay, colleagues, we're going to go through a few housekeeping items. Bear with me on Senate Bill 176 and Senate Bill 178. I would like a motion to re-refer those bills to Education and Health. May I have a second? Okay, all those in favor signify by saying aye. Oh, is that a roll call? It's a roll call vote. All those in favor, please vote on the board.
Ayes 10, noes 0.
Thank you. Okay, we, at the request of the patron, Senate Bill 417, I'd like a motion that it go by for the day.
So moved.
Okay, motion's been made and seconded. All those in favor signify by saying aye. Aye. Okay, I would like a motion to roll Senate Bill 529, patron is Senator Jordan, into Senate Bill 391, patron is Senator Pekarsky, and both senators shall be named as chief co-patrons. May I have a motion? Okay, motion has been made and seconded. Will the clerk please open the roll?
Ayes 11, noes 0.
Thank you. Lastly, there's a motion to roll Senate Bill 162, patron Senator McDougall, and Senate Bill 467, patron Senator Obenshain, into Senate Bill 39, patron is Senator Favola. Both senators shall be named as chief co-patrons. May I have a motion?
So moved.
A second? Thank you, colleagues. Will the clerk please open the roll?
Ayes 12, noes 0.
Okay, thank you. Is Senator Boysko here? I know she has to chair a committee, and she did have a bill she wanted to go over quickly. Okay. I don't see Senator Boysko. All right, committee members, I'm going to ask for your indulgence. I usually don't present first, but we have a couple of speakers who are here and have traveled to be here. And I'm going to present the Kinship Has Foster Care Bill. It is Senate Bill 39. And Senator Servell, would you serve as chair? Senate Bill 39 has been a long time in the works. It is a bill that looks familiar to some of you. I have introduced it for 2 previous years, and then this last 6 months prior to January, I did work with the administration, Janet Kelly, and at the time Senator Monty Mason was also on the task force to create a formal vehicle to ensure that relatives and victim kin become a priority in terms of placing children who are at risk of foster care. All the evidence shows that our children do much better if, in fact, they can be placed with relatives they know, victim kin they know, maybe stay in the same school system, keep the same friends. They're already going through a traumatic period. So what this bill does is it actually requires the local boards of social services to make every effort to place a child at risk, again, of being removed from his or her home. They have to make every effort to find a relative or victim kin, and if they cannot, they have to explain to the commissioner what their efforts were and why they couldn't find an appropriate relative home, which is a big step forward. That's a big sort of turning our system around a little bit in a positive way. And before I continue, I do want to draw the attention of the committee to an amendment in the nature of a substitute and ask you to adopt that amendment.
Okay, is there a motion to adopt the substitute? Okay, it's been moved and seconded we adopt the substitute. All those in favor say aye.
Aye.
Anybody opposed? And the substitute's before us. Can we get that distributed?
Okay, thank you, Mr.
online?
Chairman. So let me go on and explain what these alternative living arrangements are. When an alternative living arrangement becomes possible, Child Protective Services is charged in my bill in creating a safety plan. The safety plan would include the relatives or host caretaker family, the biological parents, Child Protective Services, and anybody else who might be important to a safety plan. And in this safety plan, it actually outlines what the responsibilities are of the biological parent, and more importantly, the caretaker parent, and actually specifies that there must be authority for the caretaker family, if you will, to sign certain school papers or medical papers if that should come up. Oftentimes, a child does need medical treatment, and it's difficult if a caretaker family does not have the authority to allow the child to access those services. An important point in this plan is the safety plan cannot be any longer than 90 days unless there's a significant reason to renew that plan. And after 90 days, of course, the parents or the caretaker family can decide they want a renewal. They don't have to re-up. This is a voluntary arrangement, but Child Protective Services then has to facilitate a meeting with all of the stakeholders to ensure that what the situation might be if the child can be safely returned to a biological family, or if the child must remain in the caretaker's home, or they have to find another alternative for the child. A lot of folks looked at this document, and we tried to make it as comprehensive as possible while balancing certainly the safety and needs of the child with the rights of the parents and the responsibility of the state. I think a couple important points. In the past, a caretaker family, this relationship was informal. Child Protective Services did not have rules or regulations to follow. And that situation, in fact, had led to a very tragic situation, which you'll hear about when I complete my presentation. So as part of the safety plan, the caretaker family will be evaluated. There will be an assessment. Their background checks will be looked at. There'll be a regulatory process that will explain exactly what should be considered in terms of considering a place to be safe. And that's really important. And there must be a follow-up visit to the caretaker's home within 2 weeks of the placement. And that's another very important thing. We're not just turning the child over to a relative or victim kin family and walking away. We're ensuring that that place is safe and the family is getting whatever supports they might need. But most importantly, that the caretaker family actually meets a certain set of criteria. So if we come to the conclusion of the safety plan and the determination is that a child, in fact, the parental rights do need to be terminated, there's a process for that in this bill. I'm going to stop where I am, and I know I have some presenters. This is a huge step forward. The governor has money in the budget for this. And as I mentioned earlier, I did work with the administration, and somebody from I think Ms. Kelly, who was formerly with the administration, will be here to speak to the bill. Having taken some of your time, I will now step aside.
All right, Senator Obenshain.
Mr. Chairman, members of the committee, I'll be brief, but I'm now chief co-patron of this bill, and I want to thank Senator Favola for her work on this. And this is not my area. It's not my committee. I've never served on this committee. I know very little about kinship care, but I came to have an interest in this bill and this subject area due to an absolutely gut-wrenching situation in Augusta County, Virginia. And it I think, is providential that we learned of this year and have had an opportunity to incorporate in this bill, this really comprehensive and good bill that seeks to achieve the great things that kinship care offers, the protection for those unbelievably vulnerable members of our community. You're going to hear in a couple of minutes from the Commonwealth's attorney in Augusta County. There, a 2.5-year-old was placed in a alternative living arrangement by her meth-addled mother, who was facing jail time, and of course, who does she turn to but another meth-addled mother to accept care of her child. And that child was delivered by a child protective services worker to somebody who was serving active home confinement with an ankle bracelet, who had recent drug convictions and a live-in with multiple felony convictions. They dropped this baby off and never checked again. This baby disappeared, and the caregiver and her live-in were sadistic enough that they captured videos and still images of the horrendous torture of this baby. The baby was never found. She was murdered, and the caregivers were convicted, incredibly, due to the incredible work of the Augusta County Commonwealth's Attorney's Office, even without ever recovering the body in this case. It is so critical that we also incorporate these guardrails that are incorporated in this bill that encourages these placements, but make sure that we are not ignoring the vulnerability of these children and the questionable judgment at times of some of the folks who are seeking to place their children in these situations. So I thank the administration, I thank Senator Favola, and I thank the committee for consideration of this bill.
Thank you, Senator Obenshain. Senators, I had a quick question to maybe just get a baseline question answered. So, practicing law, you come in to get involved in these situations time to time, and I have a question that doesn't relate to where the child, the ability of the family that the child goes with to care for them, but the situation where the parent, who is the remaining parent, who has to consent under this, has questionable judgment. So I had a situation once where one parent murdered the other and had some serious mental illness issues and had conflicts with the murdered parent's family, obviously, and so wasn't really willing to consent to the other parent's family caring for the child, and her family wasn't even in America. And so the smart thing to do was to put the child with the other parent's family, but she wouldn't have consented to it under this statute. And I was wondering, under either existing code or somewhere in here that I've been able to find, whether or not there's still some sort of priority process where the DSS would try to get the child with family prior to, and this mother was not capable of exercising proper consent at all, because that would have been a good idea too. So I'm trying to understand that.
Mr. Chairman, members of the committee, the existing code, of course, does have emergency removal if the child is in imminent danger, which you probably are familiar with. But under this bill, the caretaker family would have to go through an evaluation. So both parents in that household, every adult in that household, according to my bill, would be subject to a complete evaluation, including background checks. There will be regulations that DSS has to issue by January 1, 2025 that will go through some specific detail.
Right, but Senator, my question is, if the parent won't consent, is there a process where DSS would prioritize a family? If one biological parent doesn't Looks like he has an
consent,
answer.
and the other, Carl?
Get that, sir. Yes, good morning, Mr. Chair. Carl Ayers, Deputy Commissioner at DSS. So in that situation is these agreements are purely voluntary. So if the parent does not consent to this, then it would not fall under this section from that end of it. Then it would fall under the current sections that exist under the courts and taking that further. This is completely voluntary. If the family does not consent to this, then it falls into the next section. If you're talking about a non-custodial parent, then whenever you get into that formal process that goes through the courts, you have to follow both sides of the family the same way as you would for this. But in the event that the parent does not consent, then this would not apply in those specific situations.
Yeah, no, I've read that. My question's a little different, but you all keep going, and I'll talk to you separately about it.
Okay.
Thanks.
All right, thank you.
Senator McDougal wants to speak.
Mr. Chairman,
Two
I think
people
the
in
fact
queue,
that
too.
you see individuals from multiple parts of the state, multiple parties focus on this indicates how important an issue it is. And it's interesting that we had constituents come from different directions to get to the same conclusion. One of the things that I think is past what we can do with this legislation, but we need to stay focused on, is making sure that those family members who are related, who now are in a custodial relationship with the children, also receive those same resources that a stranger would receive if they were to have that custodial relationship. So there is going to be a financial piece to this as we go forward. And that's one of the things we've seen historically, is that there are families who are willing to take a child, but they don't have the financial ability to do it. And because the way it's been structured, those families cannot receive funding, but a family who is a stranger that's willing to step in could receive funding. And that's just not logical at all. And so hopefully as we continue through this process, we'll be able to make sure that we've addressed that too as it moves upstairs.
Okay, thank you, Senator.
I may have a few other speakers. I do want to say that part of the dilemma that Senator McDougal mentioned is the federal law, because Title 4E does require the child to actually enter foster care, and that the family that takes the child go through official foster care training. We're trying to prevent that. So we're looking at other revenue streams, and we have a very creative team behind us. I'm done. Does anybody else want to speak? Okay. Is there somebody on Zoom?
Ms. Kelly, welcome.
Thank you. Good morning, Mr. Chairman and members of the committee. Thank you so much, Senator Favola, for your work on this bill and for your work over the last few years to get us to this point. I am a former secretary of the Commonwealth in Virginia, and until last week was a special advisor for children and families for the Commonwealth. Most importantly for this morning, I'm a kinship parent. As any parent knows, clarity is kindness. When you give kids very clear expectations and details about how things are going to work, it allows them to operate with confidence and security. Let's be honest, adults are not that different. Systems need clarity too. And in this case, the foster care system needs much needed clarity on kinship processes, as you've heard this morning. When I became a kinship parent 12 years ago, I was a lot of things. Overwhelmed, frenetic, a lot of days, but also confused. I did not understand what this kinship care system was. Not many people did back 12 years ago. I want to acknowledge the work that the local and state DSSs have done over the last 12 years to improve those things. I think that my experience would be a lot different today. I was confused about whether and how his bio family, if they were able to become healthy and stable, might be able to get their child back. Those processes and procedures are to this day not clear enough, but this bill would fix that. I was confused about why the official policy of the Commonwealth was to divert kids out of the foster care system and then do very little, if anything, to support those kinship parents. As Senator McDougal said, it's a shame that kids have to go into foster care because the support isn't there for these parents, and this bill would also remedy that. I can only imagine, I was Secretary of the Commonwealth, and I was confused. And I can only imagine what your average typical Virginia family must feel like if I were confused. And I can only imagine what kids feel like when there's no clarity. They've already encountered trauma to get into foster care or to be at danger. And they have also encountered the confusion of being placed with a family member. And so we need guardrails. We need this clarity. Imagine running this committee without Robert's Rules of Order. Imagine being a senator without the support of your legislative aid. Imagine doing your job without the very little and not enough stipend that you get. That's what it's like to be a kinship parent in Virginia right now. And so we desperately need this. I want to say, lastly, this is a key recommendation of the Safe and Sound Task Force. We had several kids who should have gone into foster care, or they should have been supported in their kinship family, better off. And the family just wasn't supported. And so over time, that kid was not in a great place and ended up sleeping in an office. This is a culmination of 10 years of work from many, many stakeholders behind me and the state and local DSSs. We as a community and stakeholder group have done all we can. There has been a lot of creativity to solve this problem, but now we're coming to you with this solution because we've hit walls and we need your action. So I strongly urge you to vote for Senate Bill 39. Thank you again.
Thank you, Ms. Kelly. I'm trying to figure out this queue over here. I think Senator Boysko is in it, and Senator Jordan has a question, I think, right? Senator Jordan, you have a question? Where's Boysko?
Thank you, Senator Favola, for carrying this bill. I just wanted to kind of state, because we've worked on some of these issues over the year, I know the answer, but I think for the clarity of the committee, can you also explain how this increases outcomes and the possibility later for unification and the increases in opportunities that kinship provides, so the committee can be aware of that?
Thank you, Senator Jordan. We have had many briefings on this as members of the Commission on Youth, and I will just say that the beauty of this bill is not only that it keeps a child safe and reduces trauma, it also enables the biological parents it gives them time to get their lives together, whether they have to go through substance use disorder training or rehabilitation, or whether they have to get some other aspects of their life together. This bill enables that opportunity. So in some cases, the child will be able to safely return to the biological parents. But in the meanwhile, while the parents were struggling and in a period of crisis where the child was at risk, the child could be safe. All of the studies demonstrate that children do much better when they are placed in a home that they are familiar with, where they can maintain their own relationships or their relationships with friends. It's a way to reduce the trauma on a child. This is incredibly traumatic to have the child removed, even though the situation is unsafe. And we do want the very best for our children, and we want them to not suffer emotional scars for their entire lives because we didn't have a system that adequately helped them. I don't have the studies at my fingertip to give you citations, but I can certainly provide them if that's your wish.
Mr. Chairman, I have on the line an expert witness. I didn't want to ask the committee to hear him before. Ms. Kelly testified about the tremendous benefits of kinship care, but if the committee would listen to Tim Martin, the Commonwealth's attorney from Augusta County, he wants to address very briefly the importance of these critical guardrails. There is a handout that goes along with his testimony, and I would warn the members of the committee, if you do not want to see this handout about the perils, don't take these pictures, okay? Don't take the handout. But this case it was life-changing for those who were involved in it from the prosecutorial side and the law enforcement side. So, Mr. Chairman, if the committee would link up Mr. Martin,
Okay.
I'd be grateful.
You
Thank
got
you.
him online?
Yes, sir. Tim Martin, you may now unmute and speak.
Thank you so much, Senator Obenshain and Senator Favola. Can you all hear me?
Yep, we can hear you.
Okay. Is it designed such that you should be able to see me too, or is audio how we'll do it?
They have to be visual.
Please turn your video on,
have-
and we should be able to see you in the room. Thank you.
It doesn't give me a video option. There's no camera to use.
We can
But
hear
I'm
you
happy
fine.
to proceed by audio if you'd like.
Yeah, we can hear you fine. Why don't you get going and see how it goes?
Sure thing. Thank you. I really appreciate you all having me. The facts of this case are as horrific as you could possibly imagine. 2.5-year-old Khaleesi Qthriel was a really precocious and bright little girl. She had a huge vocabulary and a very sunny disposition. And on October 20th of 2020, her mother, who cared well for her, was being arrested, rightly, but she was being arrested, and she knew she would serve a period of incarceration. And so the Department of Social Services, our local one, came along with the police officer. And when the mother suggested that the child go with her sister, who was a couple of hours away, the Department of Social Services said that that would not work and forced her to choose somebody else. So, not knowing who else to choose, she chose someone with whom she had been incarcerated. And so the Department of Social Services got her in the car, drove Khaleesi over to this other house that was well cared for, and dropped her off, and never called and never went back. And over the course of the next 2.5 months, she was systematically tortured to death. They took pictures and took videos that the law enforcement folks discovered over a period of time. We have spared you that. We had a PowerPoint presentation to give, but I understand that there's widespread support for this bill. Certainly those of us who dealt with this case and who have been subject to viewing those images and understanding exactly what happened to Khaleesi are in support of it. Had there been any sort of guardrail in place, this just couldn't have happened. First of all, she never would have been placed with these folks. Second of all, there would have been some provision by which she would have been checked on. But instead, they took her to this place with these two people with extensive criminal histories, violent criminal histories, and they starved her, they beat her, they never obviously took her to the hospital to get any help. And the photos of her from the very beginning, when she was a very healthy little girl, to the 2.5 months later, wherein all of her hair had been pulled out and she had almost none left. She was emaciated and bruised from head to toe. Dr. Robin Foster from BCU Medical Center there in Richmond testified in our case and remarked repeatedly that it was among the worst that she had seen. The FBI also concurred with that, indicating that it was one of the worst cases of child torture they have ever seen, and nobody ever checked on her. And the situation here that I'd like to distinguish from some others is that the mother had someone good for her to go with. It was the Department of Social Services that stepped in and diverted her away from there. I understand there's no perfect bill, but this really gets us going in the right direction to make sure that this never happens to another child here in the Commonwealth, which is our hope.
Thank you. Senator Favola, detecting, not a lot of concern up here. So, I mean, and this is a big bill.
Are we
Why don't we have
detecting
everybody come by and
unions?
just say who they're with, support? Because I'm not sensing there's any opposition out there. Oh, one opposition. Okay.
Okay.
But if you always want to come by and say who you're with and that you support, that'd be helpful. And then we'll get to the opposition and see, get to the bottom of that.
Sure. Members of the committee, Allison Gilbreth, Voices for Virginia's Children, we support the bill. Also wanted to thank Senator Jordan for being the foster care co-caucus chair and supporting this efforts over the years. Thank you.
Okay. Good morning, Mr. Chairman. Members of the committee, I'm Leah Mills. I'm one of the Deputy Secretaries of Health and Human Resources, and I'm here to be with you today to express the administration's support for Senate Bill 39, which establishes practices and timelines in the Code of Virginia for kinship care. I want to thank Senator Favola for her tireless work. I also would like to thank Senator Obenshain and Senator McDougall for their work in this arena. And as you all know, kinship care allows children to live with their relatives safely, and it allows them to stay connected with their families. Research and common sense shows that children that are placed with their families have reaped the long-term benefits. They have more timely achievement of permanency, fewer behavioral issues, increased likelihood of being placed with siblings, decreased likelihood of using psychotropic medications, and having their established familial and cultural ties. So this is a priority of the administration, and we just urge you to support the bill. Thank you very much.
Thank you. DSS supports?
Yeah,
Okay.
in support, and just thank you, because the number of the committee members that have worked on these issues over the years, as mentioned, this has been a 10-plus year effort. So the legislation in front of you includes many of you that were in the House and then came over to the Senate as well. So thank you for your support for this bill.
Thank you.
Good morning, Mr. Chair, members of the committee. Rebecca Morgan, Virginia League of Social Service Executives President, Director of Middlesex Social Services. On behalf of local departments in the Commonwealth, we support this bill.
Thank you for being brief.
Good morning, Mr. Chair, members of the committee. Eric Reynolds. I'm the director of the Office of the Children's Ombudsman. I strongly support this bill, and I would encourage you to read my 2022 annual report that details some of the issues with the informal foster care and the ALAs that this bill addresses and fixes. Thank you.
Great. Thank you. Okay, not detecting any further speakers in support, and you have a concern. Why don't you come up and let us know what your concern is? Welcome to the Rehabilitation Committee.
Good morning. My name is Fallon Speaker. I am the director of the Youth Justice Program at the Legal Aid Justice Center. Can everyone hear me just fine? I am also a founding partner. The Legal Aid Justice Center is a founding partner of the Virginia Family Preservation Project, a joint project between Legal Aid Justice Center and the Virginia Poverty Law Center. We are in opposition of this bill today, and I just also want to, before I get started on the reasons for why we're in opposition, I want to say thank you to the members of this committee and all of the patrons who have worked really hard to try to pull this bill together this year, and we have tried to work closely with those patrons as well. We do have some concerns about this bill, and I would just state that these concerns are not just concerns that are limited to for the Commonwealth of Virginia, but are concerns that we have seen throughout the country. I myself am on a national coalition of partners who are working to resolve an issue that has come up that we've codified as the term hidden foster care system. What this bill is seeking to do is to codify what has become nationally known as the hidden foster care system. I want to provide you guys with a website. The website is unitedfamilyadvocates.org/hidden-foster-care. On that website, you will be able to find a ton of information, some of which I will share today, about some of the reasons why kinship care bills such as this, while on the face of the bill seem to be able to relieve a burden on families who are entangled in the child welfare system, also come with a number of harms that would not necessarily occur if the family were to go through the judicial oversight process, through JDR courts, and through the foster care system. So first, I would like to just note that two of our major concerns with this bill is effectively, first, the denial of due process rights to parents who are involved in parents or guardians who are involved in the child welfare system. If you review this bill, you will note that the bill does make room and allow for a parent to be notified of the right to counsel. However, no funding component is added in this bill to ensure that indigent parents are able to receive counsel. What we also know is effectively now, there is no institutional provider for parents in the Commonwealth of Virginia. So what this means is that parents will be coming to a meeting, they will be told you have the right to consult counsel. Most of the parents that we know who are involved in the child welfare system in Virginia are indigent and unable to afford counsel. So effectively, they will be not allowed to have counsel to confer about whether or not they should agree to this, as opposed to going through the formal processes that are provided through the state. In addition to that, there is information to suggest, I would just go back for a second. The reason why the right to counsel is important is not just to consult about whether or not it is appropriate for them to agree to the plan that is put forth by the department, the safety plan, but also to confer about what harms could come during the process. This bill, as written, would allow for up to 6 months of the child to remain with a kin care giver prior to judicial oversight. The reason why judicial oversight is important in this case is because this bill also requires and allows for, which is the first of its kind, allows for DSS to make a determination that imminent risk of harm is present and that the child is at risk of neglect or abuse. This is typically a finding that is made by a judge, not the Department of Social Services. Because of that lack of the parent would essentially be agreeing to that, and then in 6 months when they went to court, that finding would in so much be effective, that there was a finding of abuse and neglect. So this was kind of sort of speed track that process, if you will, without any judicial oversight, any testimony, any evidence presented to support the accusations of abuse, neglect, or maltreatment. In addition, I just want to also talk a little bit about the fact that this bill, like I said, because of the lack of counsel that would be provided through funding, is going to disparately impact low-income Black and brown Virginian families. What we know is that there is trauma that occurs during removal. This trauma is not reduced because of the kin care bill. In fact, the trauma of removal happens whether or not it's kinship placement or whether or not it's stranger or foster care. What this bill is hoping to do is to rectify the large issue of lack of funding to families who step up to be kin caregivers. And there are other options for this. Currently, right now, we represent clients. I have been representing parents, children, and caretakers for the past 12 years. Currently, I represent a family where there is a caregiver who's willing to step up as a custodial resource for the 3 children who are in care or who have been removed from their parent, and they're being refused to do so. The department is refusing to do so, specifically because it is saying that we don't have funds to pay you as a caregiver. This family has said, I don't need funds, and they have said that, yes, you do. We believe you do need funds. And so we're going to streamline you through this process. What we believe that this bill will do, in effect, is create barriers to reunification for children and parents, because the safety plans that are oftentimes created right now often have moving goalposts, and that will not change with this bill. And in fact, it will allow it to occur and continue to occur for 6 months before any court is able to review it and say it's inappropriate. I will give you some data. During the fiscal year 2018, nearly 263,000 children entered a formal foster care system. It's estimated that a comparable number of children enter informal kinship placements facilitated by child protective authorities without judicial oversight. One study estimated that at least 137,000 children were placed in kinship care arrangements by child protective services without the involvement of the court.
Yes,
Mr. Chair.
Senator Reeves. I have a question, not for the young lady at the dais, but for Senator Favola, if I could.
Okay, Senator Favola. Senator Favola, up here. We got a question for you.
Mr. Chairman, Senator Favola, does your legislation circumvent the judicial process in any way, as it typically has been through that process? Does it circumvent that avenue that the circuit courts and those judges are having to do in any way?
No, sir. The safety plan is voluntary. So let's just be perfectly clear. This is voluntary. Parents are agreeing that their child should go to a relative. This is sort of an empowerment issue, if you will. And then the maximum amount of time the safety plan is in effect is 90 days. There is an opportunity to renew the plan for an additional 90 days, but after that time, a facilitated meeting needs to take place with all of the stakeholders. The information will be looked at, a determination will be made on where the child can best be safely placed. If a decision is made that the child cannot return home, or there will not be a custody arrangement with the caretaker family, which the custody arrangements, the permanent custody arrangements are done through JDR, then the court system kicks in. If there has to be a termination of parental rights, the court system kicks in. And I have the greatest respect for the legal justice system, and it was your group that usually is very active in defending low-income families. But I do want to say there is another bill going through the General Assembly that is making an effort to have legal counsel available to families throughout this process. That's a separate bill. That's something you can think about. You make your own decision. It will take some money. But there is data out there that suggests families do better and feel more empowered, make better decisions when they do have legal counsel. I am not adverse to that. That's a separate bill.
Thank you, Mr. Chairman.
I would just.
You close to wrapping up?
Yes, I am close to wrapping up. Sorry. I would just note that while I think there is a provision that allows for the biggest issue here is the failure of due process, because there is no funding mechanism provided right now to allow for counsel to communicate with parents. Oftentimes in these situations, parents are giving the kinship care, the numbers that I just stated, the over 137,000 children who were placed in kin care placements were done so under voluntary agreements, often in which they came back and said, we did not feel it was voluntary. And that is the reason why it is important for an attorney to be assigned and for the court to have some oversight in the process early on.
I think Senator Jordan has a question too.
I have a question for you. Sorry. Are you aware of the role of the Office of the Children's Ombudsman?
Yes.
Are you aware that they are there?
Jordan.
I'm sorry. Thank you, Mr. Chair. Are you aware that they are here to intervene on the behalf of children and their safety, whether it's a rule or agency that is directly violating something that would be out of place?
Yes, I actually work with that office, and I have worked with that office and Senator Favola on several other bills as well.
Follow up, Mr. Chair.
Senator Jordan.
Thank you, Mr. Chair. So would you say there's not another agency or lifeline for children or anyone in the community that would have a complaint in regards to intervene, including legal action?
I mean, the complaint process is a lengthy process. We're talking about imminent things that are happening, placements that are happening. Right now, even with the code written as it is, oftentimes families don't have a recourse
Mr. Chair.
to arguing against these custody placements.
Senator Jordan.
The complaint system is very, very simple when it goes through that office, the Office of the Children's Ombudsman. We do that for families, caregivers, people in the broader community that want to intervene and assist children. Overall, what I would say is that we are doing things to safeguard children and in their place. So would you agree or disagree that if a child is processing a traumatic event, that they would not be best off with their next of kin?
This bill isn't addressing whether or not children would be best
Mr. Chair, my question was
next of kin. It's addressing a funding mechanism. And so I don't agree that the way in which it's seeking to address the funding mechanism is in the best interest of children or families. No.
Okay.
Mr. Chair, my question was yes or no. My question was.
No, I disagree.
You disagree
this bill
that
is
children
in
are
the best
better off
interest
with their
of
next of
children
kin.
and
Thank you,
parents.
Mr.
I
Chair.
can have a colloquy, okay? Okay, Senator Reeves.
Thank you, Mr. Chairman. As the former chairman of this committee, when we first found out about all these things that were happening that were broken, I do not disagree with you that those that are indigent maybe can afford an attorney one time as they go through that court process, and that's what brought us here today. And while an imperfect system, do you believe that we are better off today than we were 10 years ago?
Sorry. I think when you ask the question of whether we're better off today in a vacuum, right? Because what I'm suggesting is that we don't have the data to support whether or not those children who were diverted are in better placements or not. And even this bill in and of itself doesn't have any data collection mechanism for us to be able to garner that as well. There is also not a mechanism for review. So for us to come back in 6 months or 12 months, when questioned about the concerns that I have raised and how will we measure the harm, the response was, well, we don't know that there will be harm. We also don't know that there won't be harm. And I think that we have to anticipate some of the things that we do know, which are the things that I've already outlined.
Thank you, ma'am. Mr. Chairman?
Senator Reed.
I would move to report and refer to finance.
I would thank you for that motion.
Okay. Is there any further discussion on the motion? Okay.
Mr. Chair.
Senator Carol Foy.
Just briefly, so this bill actually provides for the first time due processes and notification of rights that has never existed. This bill adds new protections that get us as close to the court process as we can without bringing families through the court system, which adds additional harm to the families as well. And I can tell you that as a foster mom for 10 years, being very familiar with the foster care system and kinship care system, that this bill in a robust way addresses a lot of the issues and the lack of guardrails and guidance that has been a part of our system for far too long. And with over 4,000 children in our foster care system, we need to do everything we possibly can to keep them out of the official foster care system. And we know that the studies show that if children are placed with families, their outcomes are better. So I want to applaud the patron. I want to applaud everyone who has participated in this amazing bill, and I hope that we all can support this.
Thank you, Senator Carol Foy.
Thank you,
Is there any
Senator Carol Foy.
Further discussion on the motion to report and re-refer to finance. Okay, the clerk will open the roll. Oh, sorry.
Ayes 15, no 0.
Thank you. The bill reports and re-refers to finance. Senator Favola, I think Senator Boysko wants to go next. Is that cool? Okay, Senator Boysko, and then back to Senator Favola as chair.
Thank you so much for accommodating me. I got to chair a subcommittee in just a second. Ready?
Senator Boysko, what bill should we be looking at?
Thank you. This is SB
Hey,
378.
Madam Chairman,
Senator Servo.
really quick, I just want to make sure everybody would turn these things back into council that were distributed as part of the presentation. Okay, thank you.
So we're looking at Senate Bill 378, colleagues. Senator Boysko, go ahead.
Yes, ma'am. Thank you. In 2022, you who have been on the committee may remember that we set up a work group with the Department of Corrections, nonprofits, and loved ones of who have folks who are incarcerated to look at the communication system and the ability for us to transfer to a free phone calls and video visits for the inmates and their loved ones. So we carried legislation. I carried legislation last year, which passed. It was a product of that work group. The bill was passed through the Senate and almost got over the finish line in the House. And it is a similar bill to what I'm carrying today. Actually, I've narrowed it down a little bit. We know that providing communication services to people who are in prison is an investment in public safety, actually. Evidence shows that increased communication with family keeps both the incarcerated and the correctional officers safer, and it reduces incidents by up to 20%. Maintaining ties with family community itself is a reentry program, and studies show that it's one of the most effective ones that we know. And more contact with incarcerated loved ones is found to reduce harm of forced separation. Specifically, the benefits of communication are clear for the children. More contact with their incarcerated parents leads to healthier relationships and better outcomes. And communication with their community leads to reduced recidivism, which leaves our communities safer once they come back home. Reduced recidivism means that we have safer communities and we can dedicate resources to other needs. The economy becomes stronger when incarcerated people are able to return home successfully and incorporate themselves back into the area. Today, Virginia's families are paying more than others in other states, where calls are 1 penny a minute compared to 4 cents here in Virginia and Mississippi, where video visitation is 5 cents a minute compared to Virginia's 26 per minute. Several states and localities and others are in the process of eliminating the cost for communication. And I have supporters here from the ACL, the stakeholders who are supporting this, the ACLU, the Legal Aid Justice Center, Virginia Interfaith Center, the Humanization Project, Sisters in Prison, Social Action Linking Together, Americans for Prosperity. I would also like to point out to the body that the Police Benevolent Association, as well as the National Coalition of Safety Officers, together those organizations represent thousands of our corrections officers in the Commonwealth. They are all supportive of this bill. And I have Rose Durbin here also, who is with the Department of Corrections, who's happy to answer any technical questions you may have. This would provide free telephone calls, free of charge for our people who are incarcerated, for their loved ones or themselves. We are moving to a tablet process, so we're not talking about phones on the wall anymore. They are already in the process of distributing tablets to the inmates. So this would be the state picking up the tab to make sure that that process works clearly and efficiently.
As I recall, Senator Boysko, this bill was approved by our committee, if you will, last year, and I think it was a unanimous vote and sent to Finance. So for those who are in support of Senator Boysko's bill, if you're present, just stand up. I took a note of all the groups that were in support, and we thank you, and we understand the importance of communication, and especially if an inmate at one point is going to be released. Is there anybody in opposition to this bill? Okay, is there anybody on our Zoom who wishes to speak to this? Again, if you're in favor, I just ask you to say you're in favor of the bill. And if you're opposed, we welcome your comments.
Does anyone on Zoom wish to speak in favor of the bill? You have 3 members online who are in
There's
favor.
nobody on Zoom?
3.
There's 3 on Zoom. Okay, please open the platform. If you're in favor, please just state your name and what group you represent, if you represent a group, and just indicate your support. And if you're in opposition, please do the same, your name, the organization, and why you oppose. Thank you.
Juanita, you may now speak.
Juanita about consistent and prison reform, we support.
Thank you.
Paul Lettra.
Electra James with Sisters in Prison Reform, and we support this bill.
Thank you.
And Mrs. Nance.
Matia Nance, loved one of the incarcerated, we support this bill.
Thank you. Colleagues, the bill's before us. It must be re-referred to Finance.
Motion to refer to Finance.
A motion has been made and seconded. Is there a discussion on the motion? Senator DeSteffe.
Madam Chair, I've done some research into this, and I had a couple of questions, if I may.
Sure.
Madam Chair, Senator Boysko, we have a lot of jails that, excuse me, we have a lot of jails that provide free tablets today, and they can use them to email and everything. Is this based on telephones as put in the bill, or is this tablets?
Madam Chair, I would say that it was written saying telephone systems. My understanding in consulting with DOC is that the whole system has transferred to tablets, so there would be no need, and we could actually, I would entertain a friendly amendment to remove the minimum rate, the line 18, starting with a minimum ratio of 1 telephone per 10 inmates shall be available within each housing unit at each correctional facility.
Madam Chair, if I may.
Yes, Senator
Boysko, I'm not trying to harm your bill.
Right.
If we could just put telephones or tablets, or telephones and tablets. I will tell you that ACMAC and other jails actually provide every inmate with a tablet, so they have this access. It's my understanding that the cost of this is roughly $21.8 million for video and telephone. I think if you said one or the other, it may reduce the cost of your financial impact statement.
So you would want or?
Or, yes, ma'am.
Okay, and would you, for the sake of the committee, would you identify the line that you would want? Or I can ask General Counsel. David, could you please articulate the amendment being offered?
Madam Chair, I believe it would be on 2 lines in this. And the first one would be line 17. I'm sorry, maybe 3 lines. 14, 17. David, I'll leave it over to the attorneys to handle that.
He actually is pretty good at this. Go ahead, David.
Thank you, Madam Chair, and thank you, Senator Boysko.
Madam Chair, I think the best thing to do would be to adopt, if we want to do that in concept, I can go back and draw that up as long as I understand the will of the committee, and it sounds like we would just want to have an alternate approach. If
Do you want to draw this up and you could submit this amendment when it goes before Finance?
Yes, ma'am.
Is that acceptable,
Madam Chair?
To the committee?
Madam Chair, Senator Boysko, thank you, and thank you for indulging me in this. I'm just trying to make it so it's not more costly, and
Sure.
we can reduce the financial impact if possible, so it's less to justify.
And Madam Chair, I just want to make certain that we are preserving the right if we have for-cost video visits that would not be precluded. My interest here is to have the free telephone calls. I want to make certain that the families have the ability to still continue to have video visits. Ultimately, I would like both. So I just don't want to, I don't want to.
You may have to think about how we can
Yes,
perhaps
ma'am.
open the door to get one of these covered.
Yes.
So if, with the indulgence of the committee and the commitment of the patron to maybe work with Senator DeSteph and come up with language when this goes forward to Finance, I am comfortable supporting the motion that was made and seconded, but I will ask my colleagues if there's any other comments or any discomfort. Senator Reeves.
Madam Chair, I like the bill I voted for the last time. I find myself on Finance now, so I'm throwing up a yellow for myself and Senator McDougal till we get the final financial impact in Finance. But I support the bill. I just want to make sure fiscally.
Again,
Thank you, Madam Chair.
We're actually voting on the content of this, not the fiscal impact. That's the job of the Finance Committee. So you're voting on whether you like this idea, whether you think it's a good public policy. Okay, hearing no other conversation, will the clerk please open the roll?
Ayes 13, noes 0, 2 abstentions.
Thank you, Madam Chair.
Thank you, Senator Boysko. Good luck with your committee. Before we move on, I would like to hear a report from our ABC subcommittee. So, Senator Rouse, you had several bills before your committee.
Thank you, Madam Chair. Yes, we had several bills before our committee. We, 2 bills were asked by the patron to go by for the week. That was SB 317 and SB 416. Those bills will be heard in our next subcommittee meeting. So that left us 5 bills, Madam Chair. And
Let me ask the clerk, does the parent committee have to adopt a motion for those bills to go on? Okay, very good. Go ahead, Senator Ross.
thank you, Madam Chair. The first was on the list, but not the first bill we held, but SB 26. It's the Alcoholic Beverage Control Public Consumption Exemption. Provides that the prohibition on drinking and offering to alcohol to another an alcoholic beverage in public shall not apply when such acts are conducted on the premises of a campground located on private property at which a majority of the campers use travel or tent trailers, pickup campers, and motorhomes or similar recreational vehicles. We had a pretty good conversation about this, Madam Chair, and it reported out 6-0. SB 168, I'm sorry.
I need a motion.
Okay, sorry.
Okay, so the motion is to report and re-refer to Finance. That's what I said. Senator Reeves. That was Senator Reeves.
26.
Senator Perry. Okay, all those in favor?
Oh, I'm sorry, they did not. They did not request this.
It does not have
No,
to
ma'am, sorry.
That's not what you said. All right, I didn't have it noted. Move to report, and there was a second. Will the clerk please open the roll on Senate Bill 26?
Ayes 15, no 0.
The bill reports. Senator Rouse.
Next, we have SB 168. We heard this bill is alcoholic beverage control food to beverage ratio. It reduces the current 45% food to beverage ratio for certain mixed beverage licenses. The bill requires that a mixed beverage restaurant, caterers, or limited caterers license meet or exceed the following. For such licensees with monthly food sales of at least 4,000 but not less than 10,000, the food to beverage ratio shall be 35%, and for such licensees with monthly food sales of at least 10,000, there should be no food to beverage ratio imposed. That bill reported 6-0 by the committee.
Okay, motion has been made. Is there a second?
Second.
Second. Colleagues, if you have any questions on the bills coming out of subcommittee, since we did not take public hearing here, please feel free to ask. I guess not. Okay, motion has been made and seconded. Will the clerk please open the roll?
Ayes 15, no 0.
Thank you, Madam Chair. The next bill we heard was SB 180, alcoholic beverage control annual mixed beverage performing arts facility license. It allows the Board of Directors of the Virginia Alcoholic Beverage Control Authority to issue annual mixed beverage performing arts facility license to persons operating food concessions at any performing arts amphitheater, arena, or similar facility that has a total capacity in excess of 3,000 patrons and is located in the city of Virginia Beach. That bill reported out of subcommittee 6-0.
Okay, a motion has been made and seconded. Will the clerk please open the roll?
Ayes 15, no 0.
Next, Madam Chair, we have SB 400, the alcoholic beverage control annual mixed beverage performing arts facility license. Even though this bill is similar to the other bill, there was a section in this bill that was different. So we heard each of these bills separately, but it allows for the Board of Directors of the Virginia Alcoholic Beverage Control Authority to issue annual mixed beverage performing arts facility license to persons operating food concessions at any performing arts facility located in the city of Charlottesville, provided the performing arts facility is occupied under a bona fide long-term lease or concession agreement, the original term of which was more than 5 years. B, has a total capacity in excess of 550 patrons. C, has been rehabilitated in accordance with historic preservation standards. And outdoor performing arts amphitheater, arena, or similar facility that has seating for more than 5,000 and is located in the city of Richmond. Or indoor or outdoor performing arts amphitheater, arena, or similar facility that has seating for more than 2,500 persons and is located in the city of Charlottesville. That bill reported out 6-0.
Thank you. There is a motion to report. Before I do I have it? Did you hear a second? Second. Now I have a question. I thought we're looking at our bills separately. The mixed beverage performing arts facilities.
Yes.
We're looking at them separately.
We are looking at them separately. The patrons of each bill that wanted their bills to be heard separately. So out of courtesy, we heard them separately.
Madam Chair.
Senator Reeves.
As Senator Rouse stated, because there's a bunch of different moving parts, so I anticipate at some point we will get this all straight into one bill, working with Mr. Daniels and ABC, so we address all the individual members' specific concerns with regard for implementation.
Senator Reeves, I will task you with that challenge. I think that's a wonderful idea. So.
Thank you, Madam Chair.
Well, let's take a vote. Okay,
sorry.
motion has been made and seconded. Will the clerk open the roll on Senate Bill 400?
Ayes 15, no 0.
Okay. Senator Rouse.
Thank you, Madam Chair. And the last bill we heard that was for the committee was SB 657, Alcoholic Beverage Control, Annual Mixed Beverage Performing Arts Facility License on and off-premises wine and beer licenses. It defines performing arts facility and standardizes the eligibility criteria for annual mixed beverage performing arts facility license and on and off-premises wine and beer license for performing arts food concierge. Under current law, the eligibility criteria for such licenses varies by location and includes inconsistent ownership, lease, capacity, and seating requirements. That bill reported, Madam Chair, it's out 6-0.
Okay, I would like a motion. And there's a, okay, motion has been made and seconded. Will the clerk please open the roll? Okay, the clerk, strike the board. Yes. Senator Jordan.
Thank you, Madam Chair. I didn't bring it up, and I read the bill a little bit lengthier, but I'm going to abstain on this just out of respect for the patron and not causing harm, but I have some questions later I want to address. Thank you.
Okay, so I think Senator Jordan wants to work with you on on merging these three bills into one. Will the clerk please open the roll again on 657?
Ayes 14, no 0, 1 abstention.
Thank you, Madam Chair, and I believe that concludes the
That concludes
subcommittee
your
document.
report.
Yes,
Thank you, Senator Rouse. Okay, colleagues, let's move to Senate Bill 41, Senator Peak's bill, and that will have to be re-referred to Finance. Senate Bill 41.
Yes, thank you, Madam Chair. This is one that you've seen numerous times. I think the first year went straight to Finance, and then ever since then, the last 7 years, it's come here and then sent to Finance to die. For the new folks, this is a jail bill. The local jails, people are convicted of felonies, remain in local jails until a spot opens up at DOC. The actual local cost is just under $70. The actual total cost is sometimes $125. The state, when I first started, was reimbursing the local jails $12. We've now gotten it up to $15. This bill, of course, would take it up to actual rate. But we keep getting a couple dollars here and there, so I'd ask that you pass it. Of course, all your localities that have any jails that are holding state-eligible prisoners support this bill, and the only people who don't like it are the people who put the budget together. I have a couple of witnesses.
Okay, colleagues, do you have any questions for the patron? Okay.
Madam Chairman.
Senator Servell.
Thank you. Senator, isn't this that bill that had like a $50 million fiscal impact last year or something like that?
It goes, if you look at this, depends on how much you go up, there's a possibility if you went from $69, the actual total cost, to $128, the fiscal impact is anywhere from $19 to $37. And I put a budget amendment of $5 million in there.
Senator?
One point, depending on the definitions used and all of those things and what you consider, it could either be from 1.9 to 36.7, a real tight range there.
Senator Peake, my suggestion is perhaps we develop a plan for phasing in, getting to the average cost. That's my suggestion.
Yep.
You've got some speakers behind you, and we'll see what they have to say. Katie Boyle from VACO.
Yes, ma'am. Good morning, Madam Chair and members of the committee. Katie Boyle with the Virginia Association of Counties. We're very grateful for the increased support for jails that have been provided over the last several years. And many members of this committee have worked on that, and we're very appreciative. And we just would love to continue to make some further progress on some additional state support for this function. And we appreciate Senator Peake for his work on it and thank the committee for their consideration.
Thank you.
Good morning, Madam Chair and members of the committee. I'm Janet Arison with the Virginia Municipal League. I am here to support Senator Peake's bill as well, and we would really appreciate your support. Thanks.
Thank you.
Good morning. Elizabeth Hobbs from the Virginia Sheriff's Association, and the sheriffs also would appreciate the additional funding in a perpetually underfunded enterprise of running a jail with sufficient programming. Thank you.
Thank you. Okay, we will take.
Good morning, Madam Chair, members of the committee. My name is Chuck Mayer, representing Julian, a civil and human rights firm. We have an issue with the bill. We think it's written a little broadly and doesn't account for the other funds that the state gives in support of our local and regional jails. So we talk about compensating for the cost of incarcerating state responsible people. But a lot of that is already covered in the other funding that the state gives to the local and regional jails through the compensation board. So we give $198 million in support for regional jail operations, $187 million for local operations. And that accounts for about $60 per day for every person incarcerated in the jail, whether or not they're state responsible. So state responsible people make up about 15% of the jail populations, but the state funding makes up about 34%. So we're worried that the way the bill's written doesn't, there'd be some overlap there, and I think that might be part of the reason why you're getting the broad fiscal impact. It's not super clear. So we do have an issue with the bill, and thank you for your time.
I will ask the clerk, do we have anybody on Zoom wishing to speak to this bill?
Is there anyone on Zoom who wishes to speak in favor of the bill? Please raise your hand now. There are no speakers. Madam Chair.
Thank you, Senator Reeves.
Madam Chair, a question for Senator Peake. Senator Peake, are you older today?
I don't look it.
Madam Chair, let me be very direct because I know he's an
Senator
attorney.
Reeves.
Thank you, Madam Chair. Today your birthday, Senator Peake?
So I did not hear. Maybe it's
Is today your birthday?
Yes. It is apparently, but I feel much younger than I did yesterday.
Thank you, Madam Chair. Maybe we'll give you a birthday present. Thank you.
You sent me to finance. What a gift.
Madam Chairman, I would not say Senator Peake is older. He's just wiser today.
Extremely wise.
Yes. Madam Chairman, we just heard only 15% of the individuals at a local jail are state responsible. My recollection was that number was higher. Do you have any additional insight?
And what would I have is, Madam Chair, Senator McDougal, the number out of compliance inmates at 883, and I don't know, that's what from the impact statement, but I thought he said that was, I don't have the exact number. And to address Madam Chair's question, somebody may, but to have a plan, they do not want an actual figure in the code because that will make it tougher in the budget. So we bring this, we do a budget amendment, and then hopefully they put it in, but that is the resistance from the Finance Committee to actually putting a percentage or anything, because once you put a percentage in, then they're going to have to fund it, and that's why they always kill it in finance. So my plan is to come here every year, go to finance and watch it die, and then sometimes they put money in. But somebody has those figures, yes. Yes.
Good morning, Madam Chair, Committee. I'm Marcus Seelan from the Virginia Department of Corrections. As of this morning, the current out-of-compliance numbers for total state responsible inmates in jails are 888. That's the breakdown would be males at 812 and the females at 76. And that number was reduced to the question that was submitted earlier. That number was reduced partly because of the earned sentence credit and the releases that took place because of that, as well as the COVID releases that took place the year previous.
I'm glad our policies are making a difference. Senator McDougal.
Madam Chairman, so if I understand that, that's the number that's out of compliance. That is not the number of individuals who've been sentenced to a sentence that would put them in a state facility but have not yet moved to that state facility.
That's correct.
So could you also give us that number?
I don't have that number. I can try to get that for you, but that'd take a couple of days to do that.
That would be helpful if you could get that to us, and I can share it with the committee.
Yes, sir. Yes, ma'am.
Thank you. Okay, colleagues, the bill is before us. Oh, yes, Senator Williams-Graves.
On the number that was given, the gentleman that just gave the number that was given, Madam Chair, how does the closure of the Hampton Roads Regional Jail affect any of this?
Okay, I will ask the expert witness to come back.
I'm not sure about that impact. I can find that out as well.
That might be helpful. I'm sure Senator Peake would like that information also.
And I think were there 3 total jails that are being closed, proposed?
I don't know.
I know there's one in Obenchain's district and Senator Jordan's district. Is
Madam
there one
Chairman.
being closed?
Senator McDougal.
I think the facilities were in Haynesville, Sussex.
You mean state
and-
facilities?
and- yes.
Not jails, yes.
State facilities.
These are state
So
facilities.
just one jail? Just your
There's
jail?
I think Senator Williams-Graves was referring to a regional jail. Is that correct? Not a state-run jail? Because this is about money going to localities or regions.
That
who
would be
happen to
correct, but
host.
just is there any overlap? Is there any effect? That's just
By
my
the
question.
closure of the state facilities, I don't.
Is there effect with the jails?
Yeah.
I'm not sure what that impact would be. I'd have to check to see if there is.
Thank you, Madam Chair.
Okay. I'm not sure there will be, but again, include that in your memo to us.
Yes,
if you
ma'am.
will. Thank you. Colleagues, I need a motion on this bill, and it has to be re-referred to Finance.
Madam Chair, make the motion to report and refer to finance.
Second.
Okay. Will the clerk please open the roll?
All right, thank you.
Ayes 15, no 0.
Thank you. One gift.
Thank you, Senator Peake. Senator Pekarsky.
Good morning. Okay, good morning, Chair Favola, members of the committee. I wanted to first introduce an amendment that I've just passed out in the form of a substitute that is technical in nature only.
Go ahead. Is the amendment before us?
Yep, can you pass that out, please?
Okay, I would like a motion to adopt the amendment. Okay, all those in favor signify by saying aye. Aye. Okay, the amended bill is before us. Go ahead, Senator Pekarsky.
Wonderful. Members of the committee, we urge you today to support SB 391, a bill that seeks to protect the rights of public employees who are authorized to use medical cannabis. This bill provides a simple technical amendment to the existing medical cannabis employment protection code. When originally enacted, there was no intent to exclude public employees from Section Code 40.1-27.4, the Employment Protections Code for medical cannabis patients. However, it was later discovered that the definition of employer in Section Code 40.1-2 does not include public entities. Therefore, the code unintentionally restricted such protections from being extended to public employees. This further clarifies who is protected to include the Commonwealth, any county, city, town, or other political subdivision thereof, and any agency of the Commonwealth or such county, city, town, or political subdivision in the definition of employer within Section Code 40.1-27.4. The impacts of this unintentional exclusion have been felt across the Commonwealth, particularly among firefighters who too often suffer from PTSD or other physical ailments that cannabis products help them manage. What the bill would do is prohibit public employers from discharging, disciplining, or discriminating against an employee for such employee's lawful use of medical cannabis prescribed under the care of a practitioner under the laws of the Commonwealth. What the bill would not do is afford legal protection to someone who shows up at work inebriated, require employers to allow cannabis consumption during work hours, or interfere with restrictions imposed by federal law. In conclusion, I urge you to support SB 391 to provide public employees the same rights currently afforded to Virginia medical cannabis patients: protection from discrimination, discipline, and termination. We must update the code to extend this protection to public employees, especially those who work hard to keep our Commonwealth safe. And I will note that this bill passed out of House committee yesterday unanimously, and I hope it's the will of this body to do the same today. And I know that I have folks here who want to speak in support of the bill and can also try to answer questions, or our speakers can.
Senator DeSteph.
Madam Chair, I just wanted to clarify something. The way I read the original bill, it was for cannabis oil. The way I read this is not medical cannabis, it's just cannabis product and cannabis. So we're talking about, it could be any type of THC product. So we've gone from, I just want to make sure that I'm not missing something when you said that it was specifically technical in nature. This looks beyond technical in nature to me, and I just want to make sure I'm not missing something.
No, that's a great question, and that actually came from council, and I will defer to them to go ahead and answer,
Mr.
please.
May.
Madam Chair, Senator DeSteph, if you look at the substitute on lines 20 to 21, this is all, the first piece of it, this is all hinged on the fact that you have a valid written certificate issued by a practitioner. You got the reference there to 4.1-1601, which is the medical program. So that's the tie that makes this only apply to the medical program. And as far as the terminology, the switch from oil to product is technical in nature. This is a bill that has been put in for several years. And at the time this bill started, we referred to these medical cannabis products as cannabis oil. We now call them cannabis products. And even when we called it oil, it wasn't exactly oil. It was more than oil. It was just terminology. This is the more updated term, but it doesn't change the type of products you'd be able to use.
Okay, we did adopt the amendment, as I recall.
Yes.
Is that correct? Yes. I believe we did. It's not up on LIS, so it was a little confusing. It's not in the app, but it is an LIS, okay. So the question for my colleagues is that answer sufficient? Senator DeSteph.
Madam Chair, I believe I understand it as any cannabis that a medical any cannabis that's issued by a practitioner for the treatment of or to eliminate symptoms in employee diagnosed conditions. So it could be, this is truly all medical marijuana, where my understanding of the original one was just cannabis oil, which to me, there's THC A, B, and C, and we're talking about this is all of it. So thank you. I just want to make sure I understood that with the substitute that was provided.
I think there's clarity, and I want to note, we're talking about individuals who've received some kind of certification from a healthcare professional that this is needed. So it's really for medical purposes. This is not recreational while you're on the job.
Madam Chair.
Senator Reeves.
Question for council. Would this apply to law enforcement, especially those who work in vice narcotics?
Senator Reeves, I believe it would. It would apply to any governmental employer, unless you meet one of the carve-outs in subsection C.
Thank you, Madam Chair.
Senator McDougall.
Madam Chairman, I think I have a little more expansive question. Is there, I think we oftentimes have looked at law enforcement or public safety individuals differently in some of the requirements, and this would not view them differently. And I know you mentioned specifically firefighters, but was thinking probably focusing more on other employees like police officers, sheriff's deputies, or state troopers. Is there any provision, or have they staked an opinion on this?
I do not have an opinion from them. I've been working with the firefighters. This would apply to all. I mean, I personally believe, anything that is medically prescribed for a health situation, falls under this updated code section and should be protected as such, and everyone should be treated equally.
Colleagues, any other questions? Do you have those who want to speak in favor?
I do.
If you
They
do,
come
I'd
up.
like to limit your comments to 1 minute or less. Taking those who are speaking in favor of this.
Madam Chair, good morning and happy Friday. Dylan Bishop on behalf of the Virginia Government Employees Association. We represent state employees and state-supported local employees. We wholeheartedly support this bill and do want to point out that the cannabis product, if you look at the definition in 4.1/1600, it is specifically medical cannabis that's given at the advice of medical practitioners, and there are reasonable workplace safety protections in the relevant code section, whereas the person with the prescription still could not show up to work under the influence or operate machinery, and there's specific carve-outs for persons that have positions dealing with national security and things of that nature. So again, we'd ask you to act favorably on this bill. Thank you.
Madam Chair.
Senator Reeves.
Before the speaker leaves, you also represent the Sheriff's Association that does law enforcement activities, correct?
Yes, sir. I do represent the Virginia law enforcement sheriffs. I am not representing them at this very moment. In this interest, I'm not
just
wearing
a
that
question.
hat.
I'm curious where they stand.
They do not have a position on this at the time. Thank you, sir.
I can see there's going to be an issue on this, so Mr. May, while public comment's going on, has a friendly amendment. Would you please think about a carve-out for law enforcement and others? Senator Jordan, would you agree?
Yes, Madam Chair, I want to have council confirm this, but in the original iteration of the bill, Madam Chair, if council could answer this, it also requires a written medical certification. Is that correct? Okay, so this would not be everyday use, randomly someone going home on the
I think that was my fault.
Sorry.
My apologies.
Someone wouldn't be able to just go home and decide to utilize cannabis oil. So in regard to this, there has to be an additional layer where that person would have to go to a medical provider, if I'm correct, Council, Madam Chair, to be able to utilize the cannabis oil. So there's already an additional barrier that would have to be signed off by a medical professional in order to utilize this protection.
I will ask the two chief co-patrons if you would be amenable to perhaps a carve-out that law enforcement would not be covered under the bill.
Madam Chair.
Senator Jordan.
Perhaps Senator Pekarsky and I, if you have any space on your docket.
If you would like me to
Bye for the day, if that would be okay.
Conclude the conversation on this, and you two can work on it while we're proceeding with the rest of our docket.
That would be great.
Sure. Happy to do that.
I think that I can see where this is going. Senator McDougal.
Madam Chairman, if they could also include in their conversations, I was just noticing in lines 27, it talks about the U.S. Cybersecurity and Infrastructure Agency. I know we have a National Guard unit that does cybersecurity, and so does there need to be something similar language that would specifically include them in that portion? Because I think that there are some different requirements for people doing some of those things. With clearances.
And I will just say, if you can't come to conclusion by the end of this meeting, you can carry the bill over. I do think you're going to have to address some of these issues.
I will just say that this is existing code. The only thing, so what you were speaking to is already there. That was voted on years.
Madam Chairman,
Senator McDougal.
I think what I'm trying to say is, but right now those people are government employees, so they cannot. So if they are able to, and they're government employees, does it, and I think Senator Reeves, my guess is this is a security issue. So some of the people with state police, some of the people with law enforcement, some of the National Guard members probably have a different security clearance that require them to go through a certain testing. And so if they have the exemption, they could still be employees and they couldn't be required to do it, but not be able to perform the job that they were hired for. So making sure we figure that detail.
Okay, thank you.
Okay, I'm going to conclude the conversation
Sounds
on
good.
this bill, and we're going to move on to the next. And I wish the patrons Godspeed. This is going to be quite a conversation. Okay, let's move on to Senate Bill 456. Senator Marsden.
Thank you, Madam Chair. Senate Bill 456.
Senator Marsden, you.
Thank you, Madam Chair. This bill seeks to codify what we just recently did in the budget last year, kind of got the cart before the horse, creating an independent ombudsman in the Office of the Inspector General to inspect, report, and recommend changes and problem resolution for the Department of Corrections. And it's in the governor's bill this year. What happened is it came out of this chamber last year undefeated. It came out of the House undefeated, but in the budget process, it was killed in House Appropriations and then reinserted into the budget with an ombudsman and a $250,000 designation for that office. It's been, as I said before, it's also been put back into the governor's budget. But so as many of you know, we eliminated the Department of Corrections Board about 10, 12 years ago, which was created some oversight for the department. This attempts to reestablish that at a different level, and to be able to report directly to the governor and not just in the in-house operations of the Department of Corrections, and to be able to communicate directly with Madam Chair and members of the legislature so that we know what's going on in our Department of Corrections. Now, I do have 3 line amendments that I would, I guess, if I could ask Mr. May, that we would adopt these in concept. They were brought to us last night around 5 o'clock by the Department of Corrections and the Public Safety Office, and working with the ACLU, we have resolved the 3 concerns that the department has. And if I could just report quickly what those are, and then that will be placed into the bill.
I'm going to ask Mr. May to read these line amendments, and I ask my colleagues to pay attention. Pay attention. Amendments are being read. Go ahead, Senator Marsden.
Mm-hmm. The language, but if I can explain the 3 amendments, Madam Chair. The first one involved computer access, and we have determined that that can be stricken from the bill. This was to provide computer access to inmates. And it just eliminated from the bill. We agreed with the Department of Corrections on that issue, and as did the ACLU. The second one concerned photographs that may have been disseminated based on an investigation that would show the insides of a facility. So what we did was insert language from another part of the bill, which was a confidentiality clause in there that would allow the ombudsman to do it, but only under the ombudsman's discretion, that it was important to release the photographs that may show an interior part of a state correctional facility. And the third one was just a clarifying amendment that dealt with what's called tolling. Tolling is when a period of time starts by which somebody can file a grievance and the time at which they no longer can file that grievance, and it just provided clarifying language. So those are the 3 amendments that we're placing on the bill. But otherwise, it is as it was last year when it passed out of this committee and the Senate unanimously, and is already passed out of the House subcommittee, I believe, in the cognate bill. And I've spoken with Delegate Hope, and our intention is to align these 2 bills when this goes over to the House of delegates if it is the will of the Senate to have this bill come out of committee and pass off the floor. But this is a critical thing. Because it provides oversight that goes outside of the internal mechanisms of the Department of Corrections to the governor, to the legislature, so that we know what's going on. All of us are in situations where we receive complaints from inmates, families, and employees of the Department of Corrections, who feel they're being treated inappropriately. And this really gives us a mechanism to get a hold of this. There is a budget amendment that has been introduced, and I am working with Director Dodson, who has gotten off to a great start and has made a number of interesting and forward-thinking changes to look at the idea. I think there's about 29 investigators who currently work in the Department of Corrections. And what we were thinking of doing here is being able to transfer some of those investigative positions over to the Office of the Inspector General so that we do not add to the state's budget woes and evenly distribute the investigatory processes. It's going to take a while for the Office of the Inspector General and the internal investigators of the Department of Corrections to learn how to operate together and what each one of their spheres of influence and authority would be. But I think this is a great step forward. It's in the governor's budget, and we have a budget amendment to deal with additional staff, and we are working on the informal process of transferring some positions. So, Madam Chair, that is the bill, and take any questions.
Senator McDougall.
Madam Chairman, Senator Marsden, could you refresh my recollection? I see on lines 83, looks like through 157, we're creating not just an ombudsman, but a oversight committee. Did we do that last year as well?
Yes, this is there is a committee that would be involved in this and appointing the Inspector General and providing oversight for that office that will be housed at the state Office of the Inspector General.
And Madam Chairman,
Senator McDougall.
Happy to see that committee has an equal amount of Senate and House representation. So that's important. But is there in this legislation, is there a limitation on the time frame when a complaint can be filed?
If I could call on a gentleman from the ACLU who can answer that specific question.
Good morning, Madam Chair, members of the committee.
Mr. Winetta.
Sean Winetta speaking on behalf of the ACLU of Virginia. Senator McDougall, there are sort of actually to the earlier point of the line amendment that we had earlier, there is a tolling period for the internal grievance process. And with this, if there is, once that administrative remedy is exhausted, then you can step up to the ombudsman's office, to the office of the ombudsman within the OSIG to elevate a complaint. It is also a protection for officers, for correctional staff. We were very careful to include them to have that opportunity. As far as the time limit, there is not a time limit within the bill that says that they cannot submit a complaint at a future date. Sometimes people either don't have access to be able to file the complaint, or sometimes are scared to file complaints because there are issues within corrections that we see nowadays. People come out about sexual abuse, things like that, many years later because they fear doing it. We didn't want to sort of narrow that. This is really more about addressing systemic issues rather than individual issues within the agency. So that's what I would submit to you for the reason why there is not a specific time limit on submitting a complaint. What I will point out as well is that this is really an opportunity to inspect, report, and recommend. This is the Ombudsman's office does not have the authority to compel a change in policy or compel the DOC to action. Again, it's really an inspect, report, and recommend.
Senator McDougall.
Ma'am, so if somebody came forward today and there was an issue 25 or 30 years ago, they could bring that forward now, and that would be reviewed, even though there might not be records for 25, 30 years ago. That's really where my focus of the question is.
Sorry, Madam Chair, Senator McDougall. In theory, yes, Senator McDougall, they would be able to bring that up. I think that the Ombudsman's office would certainly have the discretion if it is somebody that didn't receive their commissary 25 years ago. That would be something that could fairly easily be disposed of. But if it is a matter of perhaps a PREA complaint, which is something that's federally protected, if somebody had been sexually abused by staff or something 25 years ago, we have people that have been in prisons for for many decades. That would be something that I think that the ACLU would certainly hope that the ombuds would have the ability to look into and then make a report and make a recommendation to whether it's the governor's staff or the Secretary of Public Safety, or as well as the department, to try and address in whatever manner they deem would be appropriate.
Thank you. Colleagues, before we go any further, I would like a motion to adopt the amendments as Senator Marsden presented.
So moved.
Okay, motion has been made and seconded. All those in favor signify by saying aye. Aye. Okay, so the amended bill is before us. Senator Marsden, do you have speakers?
I do not,
Okay,
Madam Chair, other than the gentleman here from the ACLU who was, this bill was written several years ago in conjunction with a House bill that Delegate Hope had introduced, and I picked up on it last year and introduced it onto the Senate side, and we're very, very hopeful that this is just a tremendous improvement. It's based on what's been done in some other states, and I think we can really hope that this will give all of us a feeling of relief that we know that things are being looked into in the department and getting to our attention.
Colleagues, the bill is before us. It does have to be re-referred to Finance.
Madam Chair, before we second that motion, I just had a quick question.
Senator Reeves.
Senator Marsden, lines 151 through 157 talk about the committee shall at a minimum 2 random inspections of a facility each year. So those are unannounced. I'm just curious, it kind of goes through pretty detailed on how the committee is going to do that, but I was just, and I like the thought process, but I don't know how all that's going to work with identification and all that stuff, and that's not delegated to anybody, so I just want to hear your thoughts on how you're going to.
Well, I think in a lot of these matters, subcommittees of the larger committee, can conduct these random or scheduled appointments. Sometimes you want scheduled appointments, scheduled inspections, because it gives everybody a chance to really clean up, their act. Other times, and consistently, you want the unanticipated visits, so that to find out whether people are keeping up on an ongoing basis with the improvements that they have been required to make. And so these are things that the committee will work out, but this is a general guideline as to, how they should operate, and some basic standards as to what the product of their work needs to be.
Okay, colleagues, a motion is before us, and the motion is to report and refer. Would the clerk please open the roll?
Ayes 15, noes 0.
Thank you, Madam Chair, members of the committee.
Okay. Next, I'm going to go back to Senator Pekarsky, if she's ready, and then we will hear Senator Roan and then Senator Rouse. And that should conclude our docket.
Yeah.
Senator Pekarsky.
Thank you, Madam Chair. I think we have everything worked out, and we'll be able, hopefully if you can carry it 1 week for us, we'll be able to communicate and kind of bring back something that I think will adequately address the concerns, and we'll be able to pass this.
Okay, motion has been made to carry this bill by for the week, or pass it by for the week, and it's been seconded. All those in favor signify by saying aye. Aye.
Thank you.
Thank you. Okay, and I do believe I saw Senator Rome. Did I see Senator Rome? I did. Okay. Welcome.
Madam Chair, members of the committee, I apologize for being a little under the weather today, but we'll get through this. All right, so this is for SB 291, and I will note there is a budget amendment to it, and so it will have to, if it is to be reported favorably, it will have to go to Finance. So, Madam Chair and members of the committee, SB 291, in accordance with the JLARC report, recommendations 18, 19, and 21, establishes a training program for court-appointed guardians throughout the Commonwealth. No more than once every 36 months, guardians will be subject to complete the training program developed by the Department of Aging and Rehabilitative Services. Guardians will initially be required to complete this training within 120 days of the date of entry of the court appointment. The program will include the responsibilities and duties of the guardians, how to complete annual guardianship reports, how to involve and encourage participation of incapacitated adults in decisions made by such guardians, medical advocacy, and decision-making on behalf of other persons. All guardians are currently required to file an annual report with their local Department of Social Services. In order to ensure oversight and confirm that guardians complete the training, SB 291 will slightly amend the report to include a statement from the guardian on their training status. DARS shall develop and implement the training program and annual report amendments by July 1st, 2025, and will consult with the Virginia State Bar and Supreme Court and OES so that this training can be eligible for mandatory continuing legal education, which is MCLE, a program for attorneys interested in taking the course as an MCLE credit. Guardians appointed prior to July 1st, 2024 shall complete the training before January 1st, 2027.
Thank you for your presentation. I hope you're feeling better. Are there any questions from my colleagues? Hold on. Do you have speakers here?
I do, and they can certainly stay brief.
But they all agree. So if anybody who's in support of this bill, if they want to stand or
Those on the
raise their
line who wish
hand, it is an excellent bill.
to speak in favor of the bill, please
Do
raise your
I?
hand.
Thank you. Is there anybody on the Zoom
Yes, Madam Chair, one person.
platform?
You may now speak, Stephen Burns.
Madam Chair, my name is Stephen Burns. I'm an elder law attorney in private practice in Richmond, and I'm here today on behalf of the Virginia Academy of Elder Law Attorneys. I want to thank Senator Rome for her consideration of our comments over the last couple of years and putting this bill together, and we are here in support of it.
Thank you. Is there anybody else on Zoom?
No,
I
Madam
do
Chair.
want to note that our policy is that somebody speaking on our virtual platform, please have the camera on and be present in that virtual space. That is our policy. Certainly, we can make exceptions in certain cases, but if possible, please follow our policy.
Madam Chair, I had a question.
Senator Servell.
Thank you, Madam Chair. Senator Rome, I'm trying to understand, does this bill only apply to GALs that represent incapacitated people or the elderly, or does it also apply to the JLs I deal with mostly, which is ones that are appointed in child custody cases?
So I'm actually going, Madam Chair, if I can defer to one of our witnesses on that, if you'd like to, who would be able to answer that question?
Madam Chair, Catherine Harrison with the Virginia Department for Aging and Rehabilitative Services. This bill deals with the training for guardians of incapacitated adults, so it doesn't address GALs.
Got it. Okay, that was my question. Thanks.
Good question. Okay, we've heard public comment, we've heard the presentation, and is there a second? All those in favor, please re-refer to finance and have the clerk open the roll.
Ayes 15, no 0.
Ayes 15, no 0. Okay, your bill reports and it's re-referred to finance.
Thank you, Madam Chair.
Thank you. Let's go to Senator Craig, Senate Bill 263. You're last.
Good morning, Madam Chair, members of the committee. I have SB 263. This bill will statutorily require the parole board to seek input from the Commonwealth's attorneys prior to granting parole. The parole board will be required to contact the Commonwealth's attorney of the jurisdiction where the crime was committed. This proposal codifies the requirement to notify attorneys for the Commonwealth just as it does notifications for victims, and it just will codify current parole board practices, and it is a recommendation of the review of the parole board procedures ordered by the governor in January of 2022. That's basically all this bill does.
I have a question.
Yes, ma'am.
first off, I would like to know, as I recall, when we did a parole board reform bill a few years ago, we, I believe, had the parole board as one of the people who would be notified of the pending parole decision. The Commonwealth Attorney was supposed to be notified. Is that correct? Is my memory correct?
The Commonwealth Attorney of the jurisdiction.
Of the jurisdiction,
was supposed to
yes.
be notified.
That's right. I just want to clarify that.
I do have some people from the Commonwealth Attorney's Office and the Parole Board here.
Yes, Madam Chair. I'm H.C. Davis. I'm the program director for the Parole Board, and you are correct. It is in the code now that the Parole Board must notify the Commonwealth Attorney of any inmate that's going to be released. This bill goes a little further, and we want the input before they make that decision. This was started back in about a year and a half ago under the Dotson Parole Board. I was given the sole responsibility for the outreach to the Commonwealth attorneys. And obviously, if I sent out a request for an input or an opinion to a Commonwealth attorney without giving them any other information, all they had to look at was what a person did 20 or 30 years ago, obviously the answer is going to be no. They would not agree to any kind of parole. But what I had done is I've taken a snapshot of how the inmate is at this point. I take their inmate records, their vocational and educational achievements that they've done, how they feel, how they talk about their crime now when they do their interviews, what kind of family support they have, what kind of outside support, what kind of home plan they have, and also their infractions, things such as that. I give all of that information to the Commonwealth attorneys. Sending them out, and over the year and a half that we've done this, I've gotten about 80 jurisdictions total that I've sent out. Some, unfortunately, a lot of them I sent out a lot to a certain jurisdictions, unfortunately. But surprisingly, I have about a 60% return rate on all of the requests that I sent out. And more surprisingly, I've tracked the statistics. Once I give them all that information, 37% of all the respondents either do not oppose or either support parole. So it's a good avenue for the parole board to get more information before they make that decision. It's always a good thing to have as much information as you can when you're making a decision to release somebody in society. So we just asked for this. This has been a policy for the last year and a half to make this part of the code. So future parole boards would abide by the same rules.
Madam Chair.
Senator Servell and then Senator Reeves.
I have a question for counsel. David, is this bill pretty much, I looked at it really quick, is it identical to Senate Bill 1015 that we PBI'd last year, 9-6?
Madam Chair, Senator, yes, it's the same.
Right.
It's the same, I believe.
Right, Madam Chair, speaking of the bill.
Senator Servell.
Hey, we heard this exact explanation last year that this is a new policy that the parole board has implemented, and you'd all like us to codify it so that if there's any change in administration, the future parole board loses its discretion on how they operate their proceedings, and we rejected that policy last year. Has anything changed in the last 12 months?
Yes. Last year when we testified to the policy change in the code, we didn't have the statistics back then. I'd only been doing it for a few months, so I really didn't have any input on what the Commonwealth attorneys were going to say. Now I do have that input. Almost 40% don't oppose parole. So I think it's a little bit better for obviously for the inmate to have that information, and it's better for the parole board to get that more information when they're making that decision as well.
Madam Chairman, further question. Would you agree that if we pass this statute, it would restrict the discretion of the future parole board to basically operate however they choose to operate with whatever information they choose to gather, right?
That would be correct. It's the same as last year when we had a lot of changes in the parole board that taken away a lot of things that were codified would put that discretion back in.
Okay, thanks.
The flip side of it is the parole board could continue to do this whether this lands in statute or not.
That's correct.
Just to be clear.
Madam Chair.
Senator Reeves.
Madam Chair, so this says the Commonwealth Attorney may submit. So they don't have to submit, as you stated in your data, that a lot of them don't want to submit anything or take the time to do it.
Exactly.
Is that correct?
60% do, and I give them the opportunity of any way they want to respond. Obviously, with electronics now and telecommunications, I send it out by email to them, so there's no cost as far as mailing and everything. They can respond to me or the chair either by email, telephone call, letter if they want, however they want to respond.
Madam Chair, follow up.
Senator Reeves.
The only thing that gives me a little bit of pause is there's no time limit to which to respond for the board to be able to get the information in a timely manner from the Attorney General or from the Commonwealth Attorney's offices. Is that a floating deal decision based on when they project the parole to take place, so you can't set that time, or is there a way to set a time so you're not waiting, and then they drop it on you in the last minute?
Yes, so we try to get ahead of it because when the inmates come up for parole, they come up in certain quarters of the year. We know that beforehand, and they are interviewed by a parole examiner. Once they are interviewed, that's when my process will start. I will look when it comes up on the docket for the parole board to review. They normally review 25 to 40 a week. I can look down the list and I know about when it's going to come up. I try to be a month or so ahead of time asking for that input so it's all in the system when they bring that up.
Senator Reeves.
I don't give them an ultimatum, but I do tell them when I send it out that this is expected to be discussed on such and such a date if you could get it to me before then, and most of them do. We have some jurisdictions, it's within hours I'll get it, and then some within a week or so. But I try to give them at least a month or a month and a half notice when I do send those out.
Thanks, sir. Thank you,
Thank you. Are there any other comments? Okay, any other questions for there's another speaker? Oh, Senator Van Valkenburg.
Thank you, Madam Chair. What I'm trying to wrap my head around is if they're already notified and they can then send a letter on their own, this seems like a very clunky thing to do in the code, particularly because it's also on top of just being like a clunky way of getting, when they can already do it if they want. We're actually putting into the law, like we're prioritizing a person, a specific Commonwealth attorney at that time over the office of the Commonwealth attorney because you're that. So I don't understand why we would do that when there's already kind of the free will of Commonwealth attorneys to do this.
Good afternoon, Madam Chair. Nathan Green, Commonwealth Attorney for the City of Williamsburg and James City County, here speaking on behalf of the Virginia Association of Commonwealth Attorneys. We do support the bill. We saw a dramatic difference over the last few years between when we would be just notified, hey, this person's coming out on parole, versus, hey, this person is being considered for parole. Is there any information you would like to provide? So putting this into the code would make sure that we continue to get that opportunity to speak. As you've heard, not everybody speaks. Sometimes the cases are old enough that the institutional knowledge is just not there, and we can pull a report, but we really can't add to it. And as you've heard, our lack of comment does not hold up the process. But if we do have something interesting to say, we like the opportunity to say so. We are, and I'm not sure that everyone would always agree with me when I say this, but I try to promise you, we try to be thoughtful in our decision making. We try to be thoughtful in our input. We know there's no reason to notify us if our answer is just boilerplate, we oppose. We're always going to oppose. Don't bother to send it to us because we're always opposing. That's not the case. We do try to be thoughtful. We do try to look at what we know and provide at least some information to either support or to say there's nothing that we know at this time that we would oppose their parole. Again, we know that if we just blanketly say no, there's no reason for us to be involved in the system.
I will ask the patron, do you have any other speakers lined up?
I'm not sure if there's anybody against these.
Is anybody against this proposal? Let me turn to the virtual platform. Please indicate if you agree, state who you are and a group you represent, if you represent a group, and just indicate your concurrence or your objection to this bill. And please state why you would object.
There is currently no one online who wishes to object, Madam Chair.
Okay. Okay, colleagues, the bill is before us.
Move the report. Second.
Okay. The motion has...
Chair, substitute motion of PBI.
Second.
Okay. Substitute motion has precedence. Substitute motion to PBI has been made and seconded. Will the clerk open the roll?
Ayes 10, noes 5.
Okay, colleagues, let's move to Senator Rouse, Senate Bill 182. Oh, wait a minute. Is there a motion? I will ask the clerk. There is a motion by Senator.
I can't. I wasn't on the prevailing side.
I'm on the prevailing side. Will somebody on the prevailing side ask that we
Chairman,
reconsider the vote that was
Having
just
voting
taken?
on the prevailing side by which we just PBI'd that bill, I'd move to reconsider that vote. Second.
263, second.
Okay. There's a second, and I believe that we have to vote on the board for reconsideration, and this is usually as a courtesy, we all vote yes. Green, that's green.
First, you got him straight down there? So he understands.
Do you have his?
Thank you, Madam Chair.
Ayes 15, noes 0.
Okay, so we're now back to Senate Bill 263.
Chair, move to PBI.
Vote to reconsider. Motion to PBI has been made and seconded. Will the clerk open the roll?
Ayes 8, noes 7.
Thank you, Madam Chair.
Okay. Thank you. Now we're going to move on. Senator Rouse.
Thank you.
Senate Bill 182.
Thank you, Madam Chair. I bring before you SB 182. I'm here to present SB 182, which basically empowers the Virginia Alcoholic Beverage Control Authority to modernize its online advertising regulations by allowing manufacturers to help consumers locate products. Stakeholders in the manufacturing community have approached ABC about modernizing advertising regulations, and ABC has indicated they would prefer that the General Assembly pass legislation instructing them to undergo a regulatory process before doing so. 28 other states and D.C. already allow online advertising to allow manufacturers to help consumers locate products. This legislation would authorize the ABC to promulgate online advertising regulations to bring Virginia in line with the majority of other states. It would allow ABC to bring stakeholders together through its normal regulatory process to consider this issue. And this legislation is supported by Anheuser-Busch, the Distilled Spirits Council of the United States, the Molson Coors Beverage Company, the Virginia Craft Brewers Guild, and the Virginia Wine Council.
Thank you, Senator Rouse. I would like to hear from anybody who is in favor of this bill. If you could just come up quickly and say you support this bill.
Anyone online in favor of the bill, you may raise your hand now.
Good morning, Madam Chairman, members of the committee. Ken Hutchison with Old Dominion Public Affairs here today representing Anheuser-Busch. We appreciate the senator bringing the bill forward and all of the stakeholder work on the question. Thank you.
Thank you. Anybody else wishing to speak in favor, or if you don't wish to speak in favor and you just want to stand up and say you're in favor, that would be okay. Supports this. Okay. Mr. Boykin, do you have an opinion on this? Okay. Is anybody in opposition to this bill?
Anyone in opposition?
Do we have any speakers on the virtual platform?
No, Madam Chair, we do not.
Okay. A motion has been made and seconded, does not have to go to finance. It can be sail out. Senator Reeves? Okay, well, motion has been made and seconded. Will the clerk please open the roll?
Ayes 15, no 0.
15, no 0.
Thank you, Madam Chair.
Reports. Okay, according to my notes, we have concluded our docket. Is that correct, Mr. May? Okay. I'll entertain a motion to adjourn. Has been re-referred. Yeah. A motion to adjourn? And second? All those in favor signify by saying aye. Aye. Committee's